Welcome to the Indian Journal of Law and Public Policy podcast.
Hello everyone, welcome to the second season of the IJLPP podcast. I'm your host Pranav Tanwar, consulting editor at IJLPP. Here we discuss major happenings of the legal and policy field. Today, for the fourth episode, we have a very special guest, Ms. Deepa Das Acevedo, who is assistant professor at School of Law, the University of Alabama. In addition to her work on employment regulation, she has worked actively on Indian law related to secularism, development of Hindu law, and the apex court judgments related to temples. She has written a number of scholarly and research work in this field, and that is where I am going to interact with her today. Thank you, Ms. Deepa, for taking out time, and I welcome you to the show.
Hi, Pranav. Thanks so much for inviting me to be a part of this.
Beginning with a slight background to your professional life before we move to legal developments, what has been your motivation or reason for interest to work in this area of Indian constitutional law?
I think there are lots of personal and family factors contributing to my interest in religion, law, temples, Indian politics. I've always been interested in belief systems, not just Hinduism, also in temples because I trained extensively as a Bharatanatyam dancer for a long time and actually spent a summer in college visiting temples in Tamil Nadu, and I ended up seeing over 60 of them. But my family background is not particularly religious. My great-grandfather was a lawyer, a freedom fighter, and spent 13 years in jail for his involvement in the Khilafat movement. So I've always been interested in the confluence of religion and law in India.
That is such an interesting background, Dr. Deepa, and wonderful to know your contemporary work traces back to roots. Thank you for sharing them. Now, just talking about your work in this particular field, so you have written a paper which is titled Secularism in the Indian Context, which was published in 2013, where you have discussed in detail about what secularism means in India and how it is different compared to how secularism is generally accepted. So you have written how peculiarly Indian understanding of secularism requires the non-establishment of religion but not the separation of religion and state. So moving on that line, what are all the issues and contradictions you perceive in India, adopting secularism, and then we have state controlling temples as public places through statutes? Do you see any justification in it, as many would have argued that it could probably be to let safeguards of the constitution enters temples too?
So I think I should clarify, and this is hardly a consensus view, but it's something that I've been thinking about and writing about since that article that you mentioned. I've always pushed back against the idea that India has adopted secularism. I think that we often discuss secularism as a fact of separation. So in the United States, we talk about the wall of separation between religion and state. In France, we talk about laïcité. So commentators tend to say that there are many varieties of secularism and that India has one particular variety. But what I was trying to argue in that initial article and what I've kind of built on over the years is this idea that secularism is better understood as a desire to separate religion and state. In other words, that you focus on intent more than on ends. And if we consider it in this way, India does not unambiguously have this intent. You could look at Article 25(2)(a), you could even look at Article 17 of the Constitution, but kind of to put it differently, the opposite of secularism is not theocracy, even though the current central administration might make it hard to believe this. It's the lack of interest in trying to regulate religion and relegate it to the private sphere. I think that whatever we choose to call that mode of politics and of religion-state relations, India has plenty of justifications for its intentions to not completely separate the two spheres. And these have been extensively discussed by scholars who would say that Indian governments is a particular kind of secularism. All of those justifications, I think, essentially amount to historical contingency matters. and I'm happy to go into them in a little bit more detail. But I think that the important thing to keep in mind here is that what we have, according to the Constitution and according to a lot of the statutory law that has cropped up under the aegis of the Constitution, is neither a secular state nor a theocratic state. It's a state that accepts religion is not just a matter of private belief or worship inside, spaces that are like the home or the temple or the church. And so the state has some obligations to ensure that religious communities don't devolve into islands of discrimination where constitutional values have no impact. But at the same time, of course, India is a democratic state, and you can't say in a democratic context that the state can reach with impunity into the deepest, most personal areas of individual thought and community life, because then citizens would no longer be sovereign in the way that they are supposed to be in a democracy. So it's up to the state, its various branches, the legislature, the judiciary, the executive, administrative branches, to restrain itself. As we've seen for some time now, the success rate on that varies. But I think if we understand India's approach to religion-state relations in this way, we don't have to explain away commitments to secularism, like in the preamble of the Constitution, given the fact of state involvement in things like temple administration. What we need to do is consider how well the balance between these two very different impulses is maintained at any given point in time.
Talking about the restraints, and this is where our next issue comes into being, which is about the Padmanabhaswamy Temple judgment. And the Supreme Court has actually held and overturned the Kerala High Court judgment, where Kerala High Court had held that Travancore royal family had no role in controlling or managing the temple. Thus now essentially the Supreme Court has conferred upon the royal family the rights to administer the property effectively in the position of a trustee. You have very closely followed the case right from its genesis in 2013 and so on, and had written a paper back then only in 2015 titled Divine Sovereignty, Indian Property Law and the Dispute over the Padmanabhaswamy Temple. So let us start with a more broad question in order to capture different dimensions on it. So what are your general views and observations on this recent judgment?
So I think it might be helpful to kind of recap the basic conundrum that's involved in the dispute. And the puzzle there, or the conundrum, is that the Covenant of Accession and a bunch of other laws between Travancore and India says that the Padmanabhaswamy Temple is to be controlled by the royal family of Travancore, but the 26th Amendment to the Constitution abolished royal titles. So the puzzle is, if there are no royal titles, is there a royal family? And if there's no royal family, can this particular family claim control of the temple? I think that there are a bunch of sub-issues under that overarching puzzle that we can see emerging in the Kerala High Court opinion and in the Supreme Court opinion. I'll just point out 3 of them. The first issue, I think, is, when we talk about the ruler of Travancore at the time of the accession, does that mean the office or the person? And the 2 courts differed on this. The second is, if we mean the person, is it Chitra Tirunal only or also his successors? And the third issue is, if we mean Chitra Tirunal and his successors, was that right extinguished by the 26th Amendment? I think overall the analysis by the Supreme Court seems reasonable. The court says very correctly that this is not a direct religious freedom case. It's more about the intersection of administrative and constitutional law and statutory interpretation. And actually, it was really fun going back over the Supreme Court opinion, because I taught a class on statutory interpretation in spring earlier this year, and the Supreme Court opinion and the Kerala High Court opinion are excellent examples of different approaches to interpreting statutory law. They just use different rules, which leads to very different results. I'm not saying that the Supreme Court opinion is the best opinion ever, or that it would have been impossible to reach the opposite conclusion, but I think there's a lot of value in being a piece of solid, otherwise unremarkable piece of statutory and constitutional interpretation. That is not a very common thing to find these days, given the opinions that often come out of the court.
You talked about how the approach of Supreme Court was different from Kerala High Court, and so like if you can give us more details as to how that reasoning came into being, like how did Supreme Court reach those conclusions just in contrary to High Court? Because what I understood was that the objective of both the judgments was sort of same. Was when we talk about High Court judgment, it talked about that it was trying to put the control back in the hands of people through government. And when we talk about the Supreme Court judgment, it is also celebrated on the same lines, that we are freeing the temples. So if the objective remains the same, so how are these reasoning getting different?
So I think that as far as different approaches under the same overarching purpose is concerned, that's just a part of legal analysis, and I think particularly common law analysis. You have the same basic texts and the same basic laws, but different judges, which equals different interpretations. I think this is an exercise that I actually used in my statutory interpretation class last term, but suppose we have a rule that says, everyone must eat adequate fruit. Your view on what is adequacy might be very different on my view as to what is adequacy, but our goals are ostensibly identical, right? I think going back to a slightly different part of your question in terms of changes in analysis between the High Court and the Supreme Court, if we take each of the sub-issues that I mentioned, the first one was when we talk about the ruler of Travancore at the time of the accession to the Union of India, does that ruler of Travancore refer to the office or to the person who held the office? The Kerala High Court said that the term ruler of Travancore refers to the office. And so once that office no longer exists, it cannot confer rights on the person who held it or who claims to hold it now. The Supreme Court said that the ruler of Travancore was referring to a particular person. The second issue, suppose that we mean a particular person. Is it the person who was the king of Travancore at the time of the accession? Or does it also include his successors who would have become the rulers of Travancore if Travancore had remained an independent principality? The Supreme Court said it also includes the successors. I think there's a little bit of slippage there in that, we're taking a phrase that refers to being a ruler, a political officer, and saying it refers to a person, but then saying it refers to the people who would have held the office. So, like I said, it's not that the Supreme Court's analysis is unassailable, but it's reasonable. The third issue that I mentioned, let's say that the ruler of Travancore means Chitra Tirunal, who was the last king of Travancore, and his successors. The question is that right extinguished by the 26th Amendment? And this was probably one of the more interesting and potentially shaky points, I thought, of the Supreme Court's analysis. The court said that the right held by Chitra Tirunal and his successors was not extinguished by the 26th Amendment because, unlike the privy purses of former royal families, the privileges that were also supposedly extinguished by the amendment were located in statutes and covenants referenced in the Article 362 that was deleted. And as long as those statutes and covenants exist at the state level and continue to grant rights to the people who were former royals, then those privileges still exist courtesy of the statutes. In other words, it becomes an issue of statutory law and legislation rather than an issue of constitutional law and amendment.
So I think, in such cases, even if we refer to Ayodhya judgment which came recently, I see, there are so much of technicalities, but the popular opinion flows in some other way. So I want to come to, the public opinion part. There are political mileages attached to such cases as well, and that's how political parties fight outside the court arena and try to get mileage of whatever the court says. So how relevant do you think is the role of public opinion as part of build up to the litigation and post litigation in such cases?
I think it varies considerably from specific dispute to dispute. So I don't think it was the same as between the Padmanabhaswamy Temple dispute and the Sabrimala dispute, even though in both cases we're dealing with two of the most prominent temples in the same state in India. I think that though overall it's undeniably difficult to continue to maintain the fiction that judges are beyond the news. Even Supreme Court justices are human beings. They have different concerns and institutional stakes, but they read the newspaper. They are affected both as individuals and as holders and, one hopes, protectors of institutions. And I think it's increasingly apparent just how much that influence comes to bear on the apex court in particular. So if we, turn for a minute to the Sabrimala dispute, after languishing in the Supreme Court for almost a decade, not an unusual amount of time by any means, but nothing was really happening aside from brief orders now and then eventually a transference, I think in 2008, to a 2 or 3 judge bench. Sabrimala the hearings finally got going in earnest after, in 2015, the Happy to Bleed campaign and the temple entry campaign by the Bhumata Brigade started. You can never prove direct causality in these matters, but I think it is hard to ignore the fact that both of those social movement campaigns began in the 3rd week of November, I believe, and then in January there were the first hearings on the Sabrimala dispute in a couple of years. And even after the opinion was handed down, there were protests, there were review petitions to a degree that is fairly unprecedented. And then the Supreme Court instituted the Constitution bench hearings on religious freedom jurisprudence. So, you would have to be very ostrich-like, with your head in the sand to say that public opinion is not doing any work in these situations. But I think what we need to remember is that in the short run, this kind of responsiveness to public opinion may indeed pay dividends for the Supreme Court, at least among some constituencies, insofar as people come to see it as more approachable, more responsive, more reflective of their values. But there are a lot of, I think, negative consequences to this sort of clear impact of public opinion. The first is that, we simply don't need a third house in Parliament. The second, I think, is that no institution can reflect everyone's values at once. This is part of the criticism that has emerged over the last several years of, for example, the Supreme Court's PIL jurisprudence, and how something that was initially meant to be an avenue of assistance for the downtrodden and the marginalized has lately become very much a tool of urban middle-class corporate interests. And that's because the particular people who occupy positions at any given time matters, even in an institution like the Supreme Court. And so although we might find it admirable that in one situation they respond to the public and behave in a way that some members of the public find appropriate. In other circumstances or at other moments in time, we may feel differently about that.
Okay, so I think when you were talking about, this Supreme Court's dependence on public opinion, one can work in small gains but not in long run. But then in your another paper, which was titled Just Hindus, you have analyzed Supreme Court decision Sabrimala, where you have said that it's a good outcome through bad reasoning. And I think, as I could understand it, was first point by you was actually neglect of devotees' opinion, and second was further damage that it has done to the essential practices doctrine. So I think you have argued quite good enough to put your case in that article. What I'm really intrigued about is the foreign law in such issues. So how do you compare it with the US court's jurisprudence on such religious issues?
So I think it is quite difficult to compare India and the US on this point, although I don't dispute that I've tried to do so myself in many instances. There are fundamentally very different premises from which the American and Indian constitutions begin. There are different institutional, infrastructural factors that make the American Supreme Court operate very differently from the Indian Supreme Court. And so I'm not sure how productively we can compare specific cases or even sub-issues between India and the US, because when I try to explain issues like the Sabrimala dispute, let alone opinions like the IJLA opinion about Sabrimala to my colleagues who are American constitutional law scholars, every second, sentence is an explanation trying to get them to understand why things are so radically different in India, just because the contexts are so different,
Right.
So, I think your starting point is so different in that you have a religious institution that is administered almost entirely by a state actor. That in and of itself makes the comparison very difficult, because in the US context, at least nominally, we should not have state actors involved in the administration of religious institutions. That we could say that a second point in the Sabrimala dispute in particular, whether it is necessary, this is the essential practices doctrine part of the dispute, whether it is necessary for someone who is a devotee of Ayyappan at Sabrimala to actually go to Sabrimala. That is an analysis of the content of religious faith, which again is supposed to be something that American courts never do, and which the Indian courts, in particular the Supreme Court, have always felt relatively free to do,
Yeah.
So I think it's an apples to oranges comparison, which is fun, but mostly ends up in a series of explanations.
Okay. Is there a potential to understand if there is a better model of secularism? Because US model of secularism is quite different from India, as far as I understand, and I think that's the very basis of the starting point as to why we can't compare the Supreme Court's approaches in both the countries. So do you think there is a better way to approach secularism, or is there a way we can pick one model of secularism rather than having unique for every other country?
I think the short answer is no. I think that, for one, like I said earlier, to me, secularism suggests a desire to keep religion separate from public life and public governance. There are different ways to do that, and you can succeed or fail at doing that to different degrees. But that impulse is to create some sort of distance or separation or privacy. I don't believe that that is unambiguously and solely the intention of the Constitution. I don't know how anyone can read our, the entirety of Article 25 and think that that is what the Constitution means for governance in India. So I think at that level, we've gotten off to a very different sort of conversation. And, there are a lot of very good reasons for not trying to effectuate the kind of separation that, say, America tries, and I should add, fails spectacularly at effectuating in India. This is something that I think has been more the province of historians and anthropologists and political scientists. There are a lot of reasons why we might view India's different approach to not separate religion and state as much as, say, the US or France or even the UK, which we should remember has a person who is both head of state and head of the official established church. I think one explanation is the decentralized orthoprax nature of Hinduism, which means that, practice matters as much or more than belief. There's a long established pre-colonial tradition of state involvement in managing religious institutions, certainly not managing them to the extent that the contemporary Indian state and state governments do, but the involvement of rulers in temple governance, for instance, is something that is long-standing in India. It's something that existed in pre-colonial societies in India, that existed during the colonial era, and that has morphed and, taken the form that we now know it to have. The existence of both large and several small religious minority populations, and the divisive effects of colonial rule and partition. All of these are reasons why we might need to make India seek something else. All of these are reasons why we might need to, or why it might be understandable that in India it doesn't make sense necessarily to seek the same type of relationship between religious communities and religious institutions and the state as exists elsewhere. So if we simply try to find one best model of secular governance and then try to apply it everywhere, I think we're ignoring a lot of those contextual factors that are deeply important.
And I think it's very interesting to go into history of how the government, leading from British governments, is tried to control religion in India. And I think you have also written a very good paper on it, but I think it requires much more deep discussion. So we'll keep that for later. So coming to the last question of the podcast. So, a lot has been happening in India, especially between Supreme Court and religion. There has been a lot of judgments, including Sabarimala. Ayodhya judgment just came recently.
Right.
And obviously the Padmanabhaswamy judgment. So, there's much to be explored and analyzed. So as the last question, what are new projects, or do you have any new projects or papers you are planning to pick up or looking forward to?
So I'm actually right now working on a book on the Sabarimala dispute with Oxford University Press. Hopefully that will be done by the end of this year. Then I'm sort of at the beginning of a new research arc on constitutional morality and judicial autonomy, both of which are things that, although they aren't specifically concerning religion and law, they have surfaced a lot in many of these opinions that you mentioned, and also in other opinions that have nothing to do with religious freedom, as we try to understand more the limits of constitutional interpretation and of the proper role of the judiciary in contemporary India. Part of a group of scholars organizing through the Law and Society Association to study these issues across a variety of national contexts. And I've worked on a few short articles out of this research so far. One is a short essay that compares Supreme Court reforms in both India and the US, because both countries are going through periods where there's a lot of conversation right now about what is the proper structure and role and level of autonomy for our apex court. And there have been some suggestions for reform in the US that would actually incorporate some of the structure that exists in the Indian court. And I've done a short project comparing those two models and to what extent, you could transpose one from one to the other. And then I have also been working on a longer research article on the CJI scandal involving the sexual harassment charges against the former Chief Justice Ranjan Gogoi that is coming out in the Asian Journal of Law and Society next year. So this is just the beginning of a new research arc, but hopefully one that will let me build off of the religion and law research that I've done for the past several years.
Okay, I think those are very really exciting ideas and much anticipated as well for academia. And I'm sure people interested in this field will love to follow up, especially on your book. And we hope to see that book in our bookshelves soon. So,
thank you.
So I think on that note, we can end this podcast. Thank you, Dr. Deepa Das, for taking out time and sharing your views with us.
Thank you so much, Pranav. This was very fun, and I appreciate the opportunity to speak with you.
So thank you to the listeners for listening to this podcast. We really enjoyed talking to Ms. Deepa about a very important side of the court's jurisdiction. We especially liked when she talked about secularism as balance and restraint on situational basis, and how even Constitution doesn't desire the large separation under Article 25 of the Indian Constitution. So for more legal readings, or if you would like to reach out to us, visit IJLPP.com. We are into our 12th issue, and Volume 7, Issue 1 is now accepting entries. Check our website to know more details on submissions. We'll be seeing you next week.
Thank you for listening to the podcast. Do not forget to check our website for more updates and legal articles. You can follow us on Twitter, Facebook, and LinkedIn. See you next time.